morning. Ms. Rolak, can you hear me?
Good morning. Yes, Judge, I can.
Great. The audio is working. Well, thank you everyone for connecting. We're going to take a little attendance here in a minute so I can figure out who all is on the phone or on the Zoom call. But let me figure out what we're doing first. We've got two motions to terminate probation flowing from Mr. Aurora's firm, maybe his new cottage industry. We've got one involving a Mr. London and one involving a Ms. Israelova, and I may not have pronounced her name correctly. Is there an order in which you wanted to handle this, Mr. Aurora?
Could we do Ms. Israelova first, since the government had consented to that one? It might be faster.
Maybe. Let's see who all. Is there anyone on the Zoom call who is here in connection with Ms. Israelova's matter? Well, everyone is here on the London matter? Okay. We do probably need Ms. Israelova. I may have questions for her.
I'm present, Ms. Israelova. I'm here.
Okay. All right.
For cosmetic business.
Okay. That's her stage name?
No, it's the name of the business for the.
Oh, got it. Okay. All right. Well, let's handle that first. Mr. Pinion, are you comfortable talking about Ms. Israelova's case? Or were you not handling that one?
That was a child division case.
Ms. McCauley had reached out to me about that. So maybe we need to see if we can get Ms. McCauley here, and we'll handle it when we get her here. If you don't mind sending a text or something.
Yes.
I'm not picking on her. I just know the email that got forwarded to me was she was on the state side of things. So I'll put that to the side and we'll talk about Mr. London's situation. Get that case up.
I just got a message from Ms. McCauley that she's trying to log on the phone.
Okay, great. It sounds like she may be talking with the family. That's what she's saying, on the phone or with a victim, maybe not this victim. We can wait on, we won't wait. We'll do Mr. London now. We have time. Ms. McCauley has time to connect. We'll handle the London matter now. It sounds like we've got a number of folks.
Computer audio, turn it on.
So,
Ms. McCauley disappeared.
oh, there she is. Okay. Good morning, Ms. McCauley.
I was sending you and Miss Nelson an email that I was on the phone with a victim and trying to log on at the same time.
we got it, and we're good. I was just getting some materials for the other matter we're handling this morning. But we'll start with Ms. Israelova. So we'll get on the record in that case, which is 17 SC 152402. We have Ms. Israelova appearing remotely. She is the Lola Lash tile on your screen, Ms. McCauley. Ms. McCauley is representing the state in this case, and we'll allow Ms. Israelova's counsel to make his entry right now, and we can get started.
Good morning, Judge. Thank you. Good morning, Ms. McCauley. Devin Rafis on behalf of Ms. Israelova. We filed a motion to terminate probation on November 9. Ms. Israelova took a non-negotiated plea before Judge Downs in July of 2017. Since then, she's completed all conditions that was imposed by her in the court. I've spoken with Ms. McCauley about the circumstances of why we're asking for early termination on behalf of Ms. Israelova. The main reason is because she is trying to open up her own business, a salon in Pennsylvania and Erie. And after going to school and spending over 600 hours studying and taking all these classes to become to get her license, the licensing board will not allow her to take the test if she is on probation. And
Even as a first offender probationer.
that's correct, because as Your Honor knows, I mean, it's still on her record until everything's finished. So they have not allowed her to take the test. So she's sort of sitting in limbo after opening up a shop, getting a lease, paying on it, getting business loans and all of that stuff. So I've had this conversation with Ms. McCauley. I've sent the proposed order that I'm sure Your Honor and Ms. McCauley has seen as well. And so the state doesn't have any objections. I'm sure she can speak to that. But if Your Honor wants to hear, we do have two witnesses today if you want to go forward. We have Mr. Aurora to speak on behalf of the charges in the plea, and we also have Ms. Israelova to speak on behalf of her circumstances.
Okay, I guess my first question, I think you could probably answer, but it may need to come from Ms. Israelova, is why not figure out up front if you can ply this trade in Pennsylvania before getting a lease, opening a shop? I'm a little underwhelmed by the sequencing here.
Sure.
What happened?
So when after she got her diploma and she went to take the test, she was advised that she couldn't when she's on probation. So she waited. I think that was back in late 2018. She spoke to her probation officer who was supervising her in Pennsylvania. Her Pennsylvania probation officer gave her a little bit of misguidance under Pennsylvania law. She was told that after 2 years of probation, it would be automatically done. And so she was like, well, I'll just wait until that's over and then take the test and do everything. So expecting upon advice of her probation officer in Pennsylvania, she took out the lease, she took out the business loans, and then realized, hey, Georgia's not allowing me to terminate.
So Ms. Israelova is in Pennsylvania right now.
That's correct, Your Honor. She's actually in the hospital. She takes care of her mother, and I'm not sure what the reasons are right now, but she's in the hospital with her mom right now.
So she had moved to Pennsylvania, supervision had been transferred through the interstate compact to Pennsylvania, and it sounds like from your pleading, she's done fine on probation. And the answer to my question is she did ask, and her probation officer in Pennsylvania was mistaken, didn't know what he or she was talking about, somehow gave Ms. Israelova information that proved ultimately maybe true if it was a purely Pennsylvania case, but she has the complication of there being really a Georgia case where Pennsylvania is graciously supervising.
That's correct, Your Honor.
Okay, that's helpful. I do need to hear either from Ms. McCauley or Mr. Aurora or both about the case. These are serious charges. Clearly, there were some mitigating circumstances given the sentence that was imposed. But when you read what the charges are and look at what the co-defendants were charged with, I need to be comfortable that we're heading in the right direction. And I'm not second guessing Judge Downs. She saw fit to give a first offender probated sentence despite the allegations in the indictment. So it would help me to understand a little bit more what the case was about and why, beyond Mr. Aurora's expert advocacy, yielded the outcome that Ms. Israelova enjoyed.
Sure. I have Mr. Aurora here to speak to that, or Ms. McCauley can speak up as well.
Ms.
Whichever-
Mr. Aurora was actually there for the plea and has probably handled the case on that end. I've only had an opportunity to review the transcripts and the information that's been provided in Odyssey.
Okay, well, let's start with Mr. Aurora and then Ms. McCauley. I'll make sure to check with you in case there's anything you want to amplify on.
Certainly. Thank you.
Your Honor, where would you like Mr. Aurora?
Podium, Your Honor, or what would
The podium would be great. You don't need to do this under oath. You
Oh.
just give me officer of the court rendition of what the case was about.
Judge, just to be clear, Miss Israelova lived in Pennsylvania, came down here for a weekend, and then that's why the case was back in Pennsylvania. She's completely from there. In this situation, she was loosely dating the victim as far as that goes. Victim asked, "Do you know anybody that I can sell some cocaine to?" She dated the defendant some years prior to that and said, you know, you can set it up as far as that goes. She comes down to visit the victim over the weekend. The victim sells 2 kilos of cocaine to the defendant.
A lot of cocaine.
Right. And so it was fake cocaine, but the defendant paid him $58,000, if I recall correctly. The weekend comes and goes. Miss Israelova goes back to Pennsylvania. The defendant finds out that he's been given fake cocaine. Unfortunately, there's some repercussions to that. And so the defendant and his people saw the victim and his people, and there was a shooting at the Cornet Club when it still existed there off Roswell Road. And Ms. Israelova, her information was gathered from the victim because everybody survived. And the police came. We waived extradition, came back down here.
So she was not even in the state of Georgia when the shooting happened. Her connection is loosely the facilitator of the drug transaction, introducing buyer and seller.
Correct. That's my understanding. She was here for the weekend visiting the victim when the deal went down. As far as that goes, she'd gone back to Pennsylvania, and anybody can correct me if I'm misunderstanding, from 3-4 years ago. And then the shooting took place at a nightclub that doesn't exist anymore over off Roswell Road.
And when we say victim, it would be victim of the shooting, but actually perpetrator of the fraud.
Right. And so there were issues that we'd raised as to why wasn't he charged with drug trafficking, because he'd gotten some fake drugs and sold them. And then unfortunately, those people didn't take kindly to have their money being taken. Consequences arose. Unfortunately, there was a shooting.
Okay. And the coincidence or link for Ms. Israelova is that she had been at one point romantically involved with a guy who's out 60 grand and was currently romantically involved with the guy who flexed the buyer.
Yes.
Okay.
And then she cooperated with the folks, and phones and everything was disclosed, and we'd shared that with the government, but I think Judge Downs saw through it. She'd given her bond in the beginning and then ended up getting the probation offer.
Okay. Ms. McCauley, does your understanding of what happened in this case differ materially from what I don't know if you could hear Mr. Aurora. Were you able to follow?
I could. Yeah, no, I heard Mr. Aurora clearly. His rendition of the facts are not significantly different than what was represented by the state at throughout the pendency of the case. It's not significantly different than what's in the police report, what I've been able to review. Ms. Israelova is not one of the shooters, but she was charged as party to a crime because it was implied that she assisted in orchestrating the robbery of Mr. Saunders, who was the ultimate victim in the case.
Okay. One of the defendants is still.
Mr. Hillard is still outstanding.
Yeah. And I trust Ms. Israelova provided any and all information she would have as to Mr. Hillard's whereabouts.
Yes, Your Honor. It was important to us because she was being threatened by him because both accused her of setting the other person up.
Sure.
So there was a lot of problems for me when I was going through this, and even after the plea. So she'd given up all her phones and whatever the police needed.
Okay. All right.
Yes.
And then it sounds like, Mr. Rafis, that Ms. Israelova has completed the important parts of her probation. She had actually today it doesn't seem like a large amount given the other case I'm about to talk about, but it was a lot of hours of community service.
Yes, Your Honor, she's completed everything that was asked of her. I was in contact with her supervising probation officer in Pennsylvania, Miss Kristen Malchano was her name. And
Can you spell the last name for the court report?
Sorry, Malchano. She told me that she was sending in a request for early termination back on 10/26 of this year. She couldn't give me any more information. It was part of the policy or something like that. But as of right now, there Fulton County put her on unsupervised status, still on probation, but everything else has been completed as far as that goes.
Ms. Israelova, how you doing today?
Hi, Your Honor, I'm good.
Tell me what you did to complete 500 hours of community service. What did you spend your time doing?
I actually joined a lot of different nonprofit organizations in the beginning. So one of the first ones was helping women that have been victimized. But then later on, once they found out about my prior charges and my records, they no longer wanted me to do community service there, even though a lot of the women bonded with me and got along with me. And I completed a lot more hours that she didn't even sign off for. I kind of came in and like reorganized a lot of things that they had there and just did a lot of different activities with the women. And but then I had found a church that I started doing community service hours. So I would cook there. And then I had found a mosque, even though I'm a Christian, but you know, they would welcome me and they basically would have a job for me at least like once or twice a week. So I would spend during like the prayers and before their events, I would basically spend time with the children and just do like activities with the children for a few hours. And then afterwards, I would help with cooking and preparing the meals and then cleaning up. And then like decorating and organizing their events when they would have like holidays or birthday parties or anything like that. So a lot of them didn't know that, you know, I was really there just doing community service, but they were willing to write off my hours for that.
All right.
So
And where are you in Pennsylvania? What part of the state are you in?
Erie, Pennsylvania.
That's where your salon will be?
Yes,
Are you staying with your mother or do you have your own place?
I have my own place.
Okay. Is your mom doing okay?
Yeah, she's okay. She had back surgery. My mom is disabled.
Okay. But she stays somewhere else, but you help take care of her.
I helped take care of her physically and financially. I had just got her a townhouse this year. I bought her a car this year. So me not being able to work right now with my salon open is really difficult financially because I support my family.
So how were you making money before if you're not making money now?
I had different jobs like as a caretaker. I was also just working in marketing as a brand ambassador. And then, so previously I had got a couple loans and I also have been investing my money. I've invested my money in the stock market.
Well, all right. Sounds like you've been doing well with that. Mr. Rafis, do you know if Ms. Israelova had a suspended sentence, not suspended probation, but a suspended sentence. So she is not on probation and she is not under any supervision. Is that something that would prevent her from sitting for the exam or getting the license that she needs to operate the salon?
I'm not entirely sure. All I know is the licensing board will not let anyone sit for the test if they're on probation, if there's probation status there.
Okay. So my thought is, based on what I've heard from you and Mr. Aurora and Ms. McCauley and importantly from Ms. Israelova, is that one, she has been a model probationer. She's taken care of her obligations and she did so in a timely manner. She has been on probation for only about a third of her sentence. And Judge Downs, in a thoughtful manner, structured a sentence that reflected Ms. Israelova's peripheral involvement in the shooting and drug deal that went on, but it was involvement nonetheless. It was a 2-kilo drug deal. I would be inclined to enter an amended sentence that has the balance be suspended, not suspended probation, but literally a suspended sentence. That said, I don't want to do that if you're going to be back in a month because Ms. Israelova finds herself in the same predicament. I think it's appropriate for there to be a few more years during which the state could do something if Ms. Israelova got involved in a similar situation. But I don't want to interfere with, and I don't think Judge Downs would want to interfere with Ms. Israelova's efforts to become an even more successful businesswoman and care for her family in Pennsylvania. So my task for you is to get an answer from whoever it would be, the licensing board in Pennsylvania, as to whether being on a suspended sentence where there is no supervision, there's no probation at all, if that would prevent Ms. Israelova from sitting for the exam. And we don't need to have this big production again. If the answer is yes, it would, then I'll do something different. If the answer is no, it would not interfere with it, then my proposal is to enter an amended sentence. And I'll figure out how to word it, but it would have the net effect of there is no more probation. There might be X years of a suspended sentence where we would continue to have the condition, don't be in Fulton County. That condition goes away if we just close out the case. So if you could do that research or have your client do that research, and then just send an email to Ms. McCauley and Ms. Nelson, but with more than just the answer is yes or no, some documentation behind that. I mean, if the answer is that's not a problem, I don't need more than that because you know what I'd prefer to do. If the answer is that would be a problem, we may need some kind of documentation. I would like it. And then I will fix the situation so that Ms. Israelova can sit for the exam. Does that make sense?
I understand, Judge.
Okay.
Judge, I don't mean to interject. Well, I do mean to interject, but I didn't think I was going to get an opportunity. Ms. Rolak has a statement from one of the victim who was shot that she would like to provide to the court. And then the other victim who accompanied Mr. Saunders on that occasion, who's listed in the victim, is on the call. It's Brad 76 and the series of numbers that follows. And I don't know if he would like an opportunity to address the court as well.
I certainly want to give both voices a chance to be heard. Thank you for flagging that. That was a good interjection.
And I also put on the chat, Your Honor, just so the court is aware, Mr. Hillier is actually in the Department of Corrections in Ohio.
Oh, look at that.
His sentence expires August 2022, so this might be an opportune time to see, once restrictions are lifted, if we can transport him.
Yep, and get him to us. Okay. Let's start with you, Ms. Rolak. It sounds like you've got a statement from, let me get the indictment up, please.
Good morning, Judge.
Good morning.
I have two statements. I have a statement from Damian Saunders, who was the original victim, and then Brad Thomas, who is on the Zoom call as well. I have a statement from him as well.
Okay,
Okay. So Damian Sanders, good morning, Judge McBurney. When I heard that Marilyn Israelova was asking for an early termination for probation, it took me back to that day when I thought I was going to die. My name is Damon Saunders, Dameion Saunders, Saunders, and I'm speaking in reference to an incident that took place on or about February 6, 2017, in which two guys, two of her gang members, tried to take my life. This was due to a dangerous situation that she willingly put together and then lied to get herself out of it. My life has changed for the most part since then. I'm a successful business owner and a proud father. I'm sure she is still a gang member. She needs to serve out her full term as any other criminal that put a hit out on a person. I am asking you to keep her on probation as ordered on the day that she was sentenced. Respectfully, Damon Saunders.
thank you.
Then this is from Brad Thomas.
Okay, hold on one sec before you read Mr. Thomas's. I just want to understand, was Mr. Saunders, who now is telling me he's a successful businessman, is he the person who sold the 2 kilos of cocaine in this case?
Yes, Your Honor.
Okay. That's helpful just to put him in context in this situation of victim and non-victim. Tell me what Mr. Thomas has to say, and then I'd like to understand his connection to the situation as well.
Okay. Dear Judge McBurney, I'm glad to hear that she has corrected a lot of things in her life and she's trying to start anew. But for me, things are not that way. After I was shot, I lost my job because I could not work. I spent months walking on either crutches or cane. I had multiple blood infections from where one bullet fragmented in my leg. To this day, I still walk around with part of that bullet in my body, which is a source of constant pain. There's a lot of things that I cannot do anymore because of my injuries. I am still paying my medical bills. I was not the intended target. I was just an innocent bystander, being that I'm going to have to pay for the rest of my life with having permanent scars, not being able to do and go about my life the way I used to. I still have a problem being in a crowd of people, and when I hear people starting to holler, I start to head for the door. I still can't do the job that I used to do, so I don't make the money now that I did back then. So every day, I get up some days I can barely walk, and I have to carry on with my life. So no, I do not think that they understand how much I suffer every day. Thank you.
Thank you, Ms. Rolak, and thank you, Mr. Thomas. I don't know if you can hear me, but I appreciate you sharing that. So it sounds like Mr. Thomas was minding his own business. Was he employed at the club? He was at the club, had nothing to do with Mr. Saunders or a bad drug deal.
I don't recall if he was a colleague of Mr. Saunders or if he was just there, but I think they were sitting at the same table based on when I went and took photographs at the club.
Okay. And do we know if Mr. Thomas is working now? He mentioned he lost his job as a result of being injured and incapacitated for a while. Ms. Rolak, do you have any information on that?
Judge, yes, he is working now. Mr. Thomas, you don't want to respond? You're able to get off mute.
Okay, I didn't want to come off mute until I was asked to.
Okay.
No, I am employed now, but not what I used to do because I cannot, due to my injury, I cannot do the job that I used to do.
What did you used to do, Mr. Thomas?
I used to do demolition and framing, and I just cannot do it because of my injury. My leg, if I do that kind of work, my foot will swell up. and I will be unable to walk for a couple of days. So I've had to move into more of a finished position in doing that kind of work.
Understand. Well, I'm sorry for that. So your livelihood effectively was taken, and now you have been forced to do not the work you enjoyed to do. Hopefully you don't hate your job now, but it's certainly not what you used to do.
No, sir, it's not. Also, I would like to say that I was not sitting at the same table as the other gentleman. I was sitting across the bar from him. And when they began to shoot, they were shooting from behind him and hit me.
Okay. You were truly unintended. You're at a bar minding your own business, and people are taking care of their business, and you get caught as a result of that.
Yes, sir.
How many times were you hit?
3 times.
Okay. Well, we are very fortunate that you're still with us, and I'm sorry for what you went through. You can understand what I'm struggling with. Ms. Israelova obviously wasn't a shooter. That doesn't mean she wasn't involved or didn't know these people or didn't make some pretty dumb decisions in trying to bring this pretty serious drug deal together. I will tell you, at our level, this is a local court. 2 kilos of cocaine is a whole lot of drugs. So these were some wheeler dealers, it's unfortunate but not surprising that this is how it all played out. And that shouldn't be a surprise to Mr. Saunders, but I guess he's feeling like he's a changed man now. I'm really sorry, Mr. Thomas, for what happened to you. I need to figure out what is the fair thing for Ms. Israelova. Your leg isn't going to get better if she isn't able to pursue the kind of work she's trying to support her family. And I don't say that to make you feel bad that you're still traumatized by what happened. You ought to be traumatized. You got shot 3 times. I need to figure out, is there's something we can salvage from all this? And it's a tricky situation, but I appreciate very much that you took the time to dial in to this session and to share with me how you're doing and how you're not doing. It's often the voice of the victim that gets cut out. Ms. Rolak does a real good job of keeping in touch with folks, and I thank her for keeping you in the loop as well. Is there anything else you want to share with me, Mr. Thomas?
Yes, I mean, I lost my home. Not only did I lose my job, I lost my home. I had to give up a lot of my possessions that I had bought over my years to able to survive the situation. So like I said, I'm glad that she turned her life around. I'm glad that she's trying to make a new start. But not only did I lose mobility, I lost my home because I could not work. I could not pay my mortgage. I had savings. I stayed there as long as I could. I know, I'm sure she did not intend on a shooting to happen. I doubt all that. But in the same sense, for her actions have cost me not only my livelihood, but my home. It cost me my relationship. It cost a lot of things for me.
Well, I appreciate you adding that additional information. I did not mean in any way to try to minimize it. I didn't realize that there was the additional financial impact and maybe even more profoundly the emotional impact because an important relationship that you had came to an end because of what you were having to go through. It's these unintended, unexpected consequences that the defendants that I deal with often don't pay attention to. They're like, you know what? No one's dead. And they think, what's the big deal? Well, the big deal is everything you just described. And I'm not in any way suggesting Ms. Israelova ever said that. I'm sharing with you what I have heard from defendants in the past in scenarios where there's this thinking, well, if no one's dead, how serious could it have been? And you're helping us understand the answer is real serious. There's the physical injury, there's the mental scarring, there's the economic damage, there's the emotional damage. And you don't recover from those things. It was helpful to hear from Ms. Rolak that you might be in a situation where if it suddenly gets loud and tumultuous, you start to panic because of what you went through, and you don't get that back, that sense of security that you used to have. I'm sorry you had to go through with that, and you're still wrestling with these things.
Thank you, sir.
You're very welcome. Thank you for giving us your time.
Yes, sir.
All right. Well, here's what we're going to do. I do need you, Mr. Rafis, to look into what I asked you to do. Hearing from Mr. Thomas makes me even less inclined to say, let's close out the case. I trust that if there was a restitution angle to this, the state would have explored it. I know there are funds for victims, and that's not a restitution piece. The state has funds for that, but it was important for Ms. Israelova to hear the impact that this situation has had. And I am mindful of the extremes we're dealing with here. Ms. Israelova didn't have a gun, didn't pull a trigger, but she played a role in the series of events that culminated in what happened. And we're hearing that there are lasting effects for Mr. Thomas. And he had nothing to do with this. It would be one thing if it was Mr. Saunders telling us how tough his life was after he flexed someone for 2 kilos and effectively stole $60,000. Mr. Thomas is just having a beer, and now his life is turned upside down, and that's not okay. But I do want to strike the right balance here, and so I will ask you, Mr. Rafis, to see if there is a way in which the sentence can be maintained, and ultimately there can be a way for the state to get Ms. Israelova back in the mix if something unfortunate happens over the remaining 6.5 years, which is what would happen along the model of what I'm describing. But I need more info, so I need you and Ms. Israelova to get that. Okay? Ms. McCauley, anything else from the state?
Nothing from the state at this time, Your Honor, although I am going to follow up with Mr. Thomas about the issues that he raised regarding his circumstances and just kind of what might be available to him. It doesn't appear that that was previously handled by the other ADA who had this case, so I will make sure that is followed up with.
That's great. I appreciate that. I know there are some resources. I don't know how that would play out given the time that's passed. But
Well, there is still an open case, so he may still be eligible.
great. Well, we can be grateful that Mr. Hilliard took his time to get here. So I will follow up with Ms. Nelson to make sure there is a hold on Mr. Hilliard, so that when he finishes his time in Ohio, he becomes our guest and not someone who's just roaming around. But that's right. The case is still open. And Ms. Rolak, I know you will continue to do your outstanding work in keeping Mr. Thomas posted as to what's happening, partly with Ms. Israelova's situation, but I think more importantly with Mr. Hilliard's, because we ought to be able to get him here, especially if in the new year, moving people around the country becomes safer and easier to do. But we'll figure that out. I'll make sure there's a hold on him, and we will go from there. Mr. Rafis, anything else?
Nothing further, Your Honor. Thank you.
All right. Well, I appreciate it again, Mr. Thomas. You've given us your thoughts and feelings about this. Ms. McCauley is going to be in touch with you. She is a very senior prosecutor with the DA's office, did not handle the case up until now, but will be plugged in at least at a high-level administrative sense as it moves forward. Thanks, everyone. And
Thank you.
Ms. Israelova, you're free to go right now. You're going to need to be in touch with Mr. Rafis as we figure out what's going on up in Pennsylvania.
Okay, Your Honor. Thank you.
All right. Let us shift to Mr. London, please. So I have something that was too big to send. So there's a Dropbox thing. I'll be able to look at that here.
Yes, sir.
And then attached to this, there is, let me, before I, this was for Ms. Israelova. My friend Rachel, she's a good person. So I've got exhibits 1 through 9, exhibit list, and exhibits 1 through 9. Plus I've got a Dropbox,
Yes, sir.
Dropbox link somewhere.
And I gave Mr. Pinion, he's got all that emails as well, the same links, and I gave him 3 more there.
Sure.
And Judge, in listening to your rationale on the last
Every
hearing,
case is different.
it's different, but I guess with the way this case is, I'll go over it with you. I mean, a suspended sentence might be the middle ground, which wouldn't be necessarily a bad resolution. This is the case, Mr. London's here in the audience. When he was 19 years old, graduated high school, he was with his best friend and his younger brother in a car. The court can imagine how that story goes.
And he was driving.
He was driving.
Right.
His brother was injured and his best friend had passed, who was a senior at Milton High School. And they were high school best friends. He was given, and this happened back in May of 2009, Your Honor, the incident. And he was given bond, but it was 24-hour house arrest. And he was on that for about 2 years before the plea coming. It took a while for the indictment to come down. And he got a 6-year confinement. He served about 4.5 years before he was released. He was released in January of 2017. He did the balance on parole, and as of January of 2017, he's been on probation. He's got about 5 years of probation currently left on it.
All right, let me play that back in just a second. So Adam Stevens was a passenger in the vehicle and he died as a result of the accident that was a result in part of your client drinking and driving when he was 19.
Yes.
Okay. There was another passenger who was injured but survived.
Yes, that would be Mr. London's younger 16-year-old brother.
David London.
Yes, Your Honor.
Okay. And David London can walk and talk and move around now, or what were the ultimate results of his injuries? You may.
This is Andrew London, Your Honor.
Hello, Mr. London. Good morning.
My younger brother, David London, is currently working. He's capable to pursue what goals he wants in life.
Okay, but you're being a little vague. Is he missing limbs? Does he have brain damage? What? Appreciate that he can work, but what's his situation?
Yes, Your Honor. He sustained head trauma at the time of the accident. He was hospitalized into the ICU for 21 days, roughly 3 weeks. During that period of time, there was a recovery period for about a year. During that time, he had to undergo therapy, physical therapy, and at some point in time, he completed his therapy, and after that point in time, began to continue his therapy. He acquired his GED, pursue a career in the movie industry. He is actively working on projects with fully functional limbs, fingers, and his mind as well, doing acting in the greater Atlanta area.
Okay. All right, thank you. And Mr. Aurora, the case is old enough that the disposition is one of these multi-page things. But you're saying it was 15 to serve 6 with the balance on probation.
Yes, Your Honor.
Okay.
So,
And ultimately, Mr. London did about 4.5 years before he was paroled.
right, he was released on July 27th of 2015 on parole. And then he started probation on January 17th of 2017. So he's been on parole for about 4 years, essentially, well, maybe. And then, so he'd have about a little under 5 years left probation.
And he had a mountain of community service.
Right.
And it
so
was modified at some point. There was an order entered where Judge Reeder, who took over Judge Downs's docket.
Judge Glanville, Your Honor, started the case, and then Reeder took over.
Right. I noticed that the sentencing sheet had Glanville on it. Why did this end up with Reeder?
I think he'd gone to family court, and so she ended up taking it over. And the modification wasn't reducing the hours. I think Mr. Pinion gave me a couple of character letters from his side. It wasn't rescinded. It's just I tried and he tried to reach out to every school in the greater metro area, but because of the allegations, they wouldn't let him speak at the school, so we had to have it modified to do the hours at another location. He'd already done them at another location. Probation wouldn't give him credit, so we had to do it sort of again.
Looks like the bulk of it was at the Humane Society.
Yes, Your Honor.
1,400 hours, and then the balance was a couple other places. So, yeah, the language of the order is unfortunate, but the total number of hours done is what was required.
Right, and he ended up doing much more than that, but yes, he did the 1,500.
Okay.
And then, as you saw in the brief, he's gotten his associate's degree, then his bachelor's degree while on probation, and now he's got his master's degree as well. And the reason we were asking for this is much like the last situation, it just being on probation, even though he's on non-reporting currently, it just hampers the employment issue. He's 31 years old now. And the only regret we've got is because he wasn't able to communicate with his best friend's family to apologize. His lawyer obviously instructed him not to do that. And then even on probation, they just said, don't contact them. There's no restriction to that, but I guess he was just following advice from the trial attorney that did it. And I know the family's probably mad about him not apologizing to them, but I didn't know, how to handle that. So we're here, and he's written a statement apologizing to the family. And I think that's in the Dropbox link or one of the letters. And
is the Dropbox link all 9 exhibits, or there's yet another? The Dropbox link is something beyond these 9 exhibits.
I don't know. I think this should be something in addition because it was a bigger, but I'm not 100% sure because my assistant did that, Your Honor.
Oh, you know what? It's something different. I'm noticing. I just opened one of them, and it's Dainty Lash Miami. I'm guessing that's not your client.
No,
it's
Your Honor.
Marilyn. They misspelled her last name. So those exhibits, everything is bundled in one place. Those would have been Ms. Israelova's exhibits.
And judges, you can just imagine there's just more character letters.
Okay.
His diplomas were included, all the drug tests that he's passed for the last 4+ years. Essentially, my point is that, he's done everything that the court would expect. We don't expect any sympathy from the victim's family, his best friend. He hasn't been able to contact them based on what he was told before. He would like to reach out to them, but just wanted to get clearance from the court because I didn't know if the bond condition continued on, through it. And it's been such a long time, and they didn't want to, raise any problems for anybody. But I'm sure the victim's parents are going to be opposed to this, as is stated in their letter. But I want them to understand that he regrets everything and wants to apologize to them. He was just told that not to contact, which is a standard bond condition, and just sort of continued after prison. And so if the court would even consider the suspended sentence for the balance based on everything that he's done at this point, is what I'd ask. As Your Honor knows, under that 1710(1)(c), whatever, after 3 years, he could be arguably taken off. And so we have all the authority here. I think everybody supports it. I obviously understand the victim's family and they have every right
So
to
not
do that.
everybody supports it, but we'll see. I'm going to give everyone a chance to be heard. Officer Crawford, do you have a figure as to how much time remains for Mr. London on probation?
Yes, Judge. Mr. London has 5 years, 2 days, and 12, I'm sorry, 5 years, 2 months, and 12 days remaining.
Okay, so 5 years and a little bit of change. Mr. London, I would like you to come up to the podium and be more specific than Mr. Aurora as to how and why being on probation is interfering with where you're trying to head professionally.
Yes, Your Honor. I appreciate the court having me speak today. When I was pursuing,
Stand up.
You can stand up straight. We'll be able to hear you.
okay, yes, sir. When I had started my bachelor's degree in computer information systems, my goal was to be able to work remotely. I knew that I was an incarcerated felon, and most companies wouldn't be able to have me in their offices due to the egregious natures of the crimes that were charged against me.
So I think, I'm sorry to interrupt. I'm not going to be rude to you, but is it not first offender?
It is first offender, Your Honor.
Okay, so you're not a felon. I just want to work through what you think the obstacles are to bettering yourself, pursuing the career you want to pursue, the obstacles that are posed by being on probation. Because if one of them in your mind is, dang, I'm a felon and I have to check the box, you, because of Judge Glanville's decision to let you be sentenced as a first offender, don't have that burden. You are not a felon. If you successfully complete your probation, either because it's truncated or you stay on probation for a few more years and you finish, you will not be a felon when it's over. That's the big benefit of first offender. And I'm sure that was explained to you many years ago when you entered your plea. So you're not a felon. I want to make sure we're not here because you've been telling people, well, I'd love to work here, but I need to tell you I'm a convicted felon. We can fix that. It's been fixed. Judge Glanville fixed that. Keep going.
Judge, before he goes, just what I've explained to him is a lot of the applications have the boxes, have you been given alternative sentencing, or if you've been a first offender, or whatever the terms might be. Plus some of the federal background checks don't recognize it. Well, obviously you know that better than anybody. So yes, you're right, he's not a felon, but in reality doesn't seem to be.
Well, I appreciate that. There are situations where you being in your status could prevent you from doing something. We just heard about it with Ms. Israelova, not your case, her case, but you use the F word, felon, and that made me think, well, wait a minute, we may be wasting our time here. If that's what you're running into, you're not a felon, but it's more sophisticated than that, and I'd like you to keep going.
Yes, Your Honor. While filling out applications for different jobs, they asked me if I ever had an arrest record. That is the answer that I had to give honestly. And with any employer that was willing to hire me, I let them know, in which case they followed separate questions, which was, what were you arrested for? Then, I disclosed to them that, vehicular homicide and serious injury by vehicle were the things that I had committed. And I was honest with them, after which point in time, several interviews going in for IT project manager, I did not receive any phone calls back. I was honest and straightforward. In other situations where they had asked about it or it otherwise, I had to disclose, it got to the probation question, like, have you completed everything for your sentence? And I would say, well, technically I'm on probation. And they're like, well, how long ago was it? It was 11 years, 10 years, 9 years relative to the time I was having my job interviews. And they said, okay, we'll call back if we're interested. And that was the situation. From that time, I've sought different means to find income and also be able to work in the job environment. Part of the reason why I pursued a master's degree in managerial sciences is because it navigates human resources departments. It gives me an understanding of company policy and also the law that goes along with being able to hire individuals. After doing that one-year master's program, I understood that each company, depending on the company, will be able to have a certain policy on who they decide to hire or not. It is not illegal to not hire somebody based on past convictions or arrest record, only protected classes. After which point in time, I continued to do my best to make income, something realistic. My mom is currently working. She's nearing retirement age. She is the one person who has stood up and been the breadwinner for my home. My dad recently has retired and he has been hospitalized in and out of different institutions due to he had some mental issues going on. He's ex-Vietnam veteran and he's now a retired pastor. I'm coming to the location where I can do much to help my family, better my life. Notwithstanding all that I had done when I was 19 years old is horrendous. I'm sorry. All these years I've wanted to speak out to the Stevens family and talk to them about the pain and trauma and conflict that they've gone through. Adam's mom, Anna, Adam's mom, John, the sisters, Olivia, and, Sophia and Hannah. I think about them and prayed about them for many, many years. I just knew that I don't know what I could do to ever bring back the life of Adam. I don't know what I could do. So I just made it my my personal mission to live my life like I was living next to Adam, and that if he saw that with his life passed, that I would make the best possible effort in my case to do something with my life and not live something that would shame him. And that's been my remorse. And I'm deeply sorry to the courts. I'm deeply sorry to the Stevens family. I'm deeply sorry to the community and everybody that's been influenced throughout the state of Georgia and the United States. I wish not, and I desire not to do anything that would transgress or cause harm to anyone else. Your Honor.
Are you working right now?
Yes, Your Honor.
What are you doing?
I work in the construction industry, and it's one of the industries that is allowed people with bad backgrounds to work, and I help people get jobs. I help people find work. I staff construction workers.
So what's the name of the company for which you're working?
The name of the company is Trades Masters. It's a
And is
temporary.
it a staffing agency for construction work?
Yes, Your Honor.
So you don't actually use a hammer to mash nails. You are helping folks who are looking for construction work find those jobs.
Yes, Your Honor.
Okay. How long have you been working there?
8 months, Your Honor.
For that?
I work intermittently doing different internships. One was an internship for an agency, a talent agency. I worked as an intern just for about a year and 3 months. Other things I would do is independent contracting type of work with the movie industry. They didn't require me to fill out a background check, and I could work for a day for $80, and it brought in money and it helped me put gas to go to community service and things like that.
When you were an intern at the talent agency, is that a paid position?
It was a position that paid $11 an hour for me to work there for approximately 20 to 30 hours a week.
So yes, it paid. It didn't pay maybe as much as you want, but it paid above the minimum wage in Georgia.
It paid enough for me to go to grad school and pay for gas.
All right. What are fields that you've looked for work in but haven't been able to find it because your sense is either because they tell you up front or the door's closed behind you that it's blocked because of your probationary status?
Yeah. Those fields would include information technology, business analyst work. Those are the roles that I feel that I'm suited for based on my education and experience.
Okay. Any reason why you can't keep working over the short term at the company where you help folks get temporary construction jobs?
With that current job, as long as I'm performing my duties and working as hard as I can, I haven't had any issues. I was honest with them about my charges and what I let them know up front. They did not follow up with questions about probation. They have me where I am responsible for overseeing other individuals. Many of those individuals themselves find themselves into different predicaments. And I understand they have me in a position where they rely on me to do my job. I feel as though if they were to investigate a little bit closer about the nature of, you know, my background, that at any given time they could release me from the position.
How do you get to work?
I drive to work, Your Honor.
How did you get your license back? I thought your license was taken as part of your sentence.
Your Honor, I submitted all documentation and things necessary. I completed a drug rehabilitation program provided by the state of Georgia while I was incarcerated at a halfway house. During that period of time, I abided by Georgia law and submitted the necessary paperwork in order to do that.
Okay. I'm just trying to understand what Judge Glanville wrote in the sentence where it says, revoke driver's license to period of probation. I mean, Mr. Aurora wasn't representing you then. I don't know exactly what that language means. But if no one has jumped up and down about the fact that you've got a license, I won't get in the middle of that. I wasn't sure what the intent was of that language. Okay. Anything else you want to? I'm going to give Mr. Aurora and you the last word as the move-ins here. I have a bunch of folks I also need to hear from. Was there anything more you wanted to share with me at this time, Mr. London?
Yes, Your Honor. I do believe in justice, and I believe what I received was just. I'd ask if it is upon the court for moderation or mercy. I made a decision in my life when I was 19 based on my faith in the Bible. Proverbs 28:13 says, "He who covers his sins shall not prosper, but he who confesses and forsakes his sins shall have mercy." And that's why I made the decision that I did when I was 19 and did not oppose the court and took an open plea before the Honorable Judge Glanville. Thank you, Your Honor.
You're welcome. Mr. Aurora, anything else at this time?
No, I'll just let Mr. Pinion go and then we can address anything if needed.
Mr. Pinion, we've got a bunch of folks on the phone, on the Zoom call here. I'm happy to hear from none or all or some, but why don't you put some structure behind it?
Thank you, Your Honor. Ms. Rolak, with our Victim Assistance Program, had planned on reading, I believe it's 3 letters, and I have copies of those for you. I've given them to the defense counsel, and I do see Mr. Stevens on the Zoom call. I believe Ms. Rolak was going to read his letter. I didn't know if he wanted to speak, but I have spoken to him, and this kind of opened a wound for him. And I think they've learned something here today. They didn't know he had his driver's license back because from reading some of these letters. So I'm sure they're not happy about that. And I know that they have not, as you would expect, recovered from the loss of their loved son, Adam. And if I may, if I could give you copies of what I believe Ms. Rolak, if that's still the plan, was going to read. So Ms. Rolak, if you want to speak up, or are you the only one that we know of that is going to speak?
So typically, Judge, I would read the victim impact statements as sent to me with a few corrections. So the copies that you have, Mr. Pinion, might vary slightly. Mr. John Stevens is on the call, as well as Miss Cynthia Hagan. I'm sorry if I'm mispronouncing your name. She is from the Mothers Against Drunk Drivers, and she has a statement as well. And I have a victim impact statement from Stephanie Goins, who was the love of Adam Stevens' life.
Explain again, please, who Ms. Goins is?
The love of Adam Stevens' life.
Okay. Well, why don't you share with me what you've got, and then I'll ask Mr. Stevens. And how do we pronounce your name? Hagen?
Hagen, that's correct.
Hagen. And then I'll see if Ms. Hagen has anything she wants to add. There's a Ms. Watley on the call. Is she here for our bond hearing later, or?
No, Judge McBurney, thank you. I am Mrs. Hagen's colleague. I am the Victim Service Manager for Mothers Against Drunk Driving of Georgia.
Okay. Well, thank you for joining us.
Thank you.
All right. We know who is who here. All right, Ms. Rolak, take it away.
So I will start with the letter from Ms. Hagen. Dear Your Honor, I'm writing to you as Mad Georgia victim advocate since May 14, 2009 for the family of the gentleman in the above photograph that was killed by Andrew David London. I have been informed by the victim's father that there is a motions hearing on November 19th to consider releasing Mr. London from probation. I strongly object to this decision. On May 12, 2009, Andrew David London showed tremendous disregard for the law in the state of Georgia and for the welfare of others when he made a series of destructive criminal behaviors. First, Andrew David London chose to drink underage. Then, Andrew David London chose to drive a vehicle after he had been drinking underage. This resulted in Andrew David London killing Adam David Stevens, his passenger, while driving under the influence of alcohol while underage. Adam David Stevens was the beloved 18-year-old son of John and Anna Stevens. Adam was a music-loving, spiritual, embracing, kind, sweet, and gentle soul who was just getting ready to start his adult life. Adam was the brother to 2 to 3 younger sisters, Hannah, age 16, Olivia, age 14, and Sophia, age 11. Can you imagine the heartbreak of these young girls who have now outlived their older brother? His family members, plus all his friends who loved him dearly, have had to live the past 138 months without him. Mr. Landon admitted that he killed Adam when the case finally went to court. He admitted he was underage and under the influence when he killed Adam. To add to the heartache, that evening, Mr. London seriously injured his 16-year-old brother in the same crash. Mr. London was supposed to go educate other young people on the destructive and dangerous actions he took that evening as part of his original sentence. Mr. London has managed to get out of doing that part of his original sentence that the victim family asked for. Approximate timeline MAD is aware of. Mr. London waited to go to court from May 12, 2009 until March 2011. Mr. London pled guilty on February 21, 2011 and received 15 years to serve 6 incarcerated. Mr. London was given first offender status, so no one can look up his GDC online. Mr. London was in prison from March 2011 to July 27, 2015. Mr. London, Andrew, was on parole from July 27, 2015 to January 30, 2017. Mr. London has been on probation since January 30, 2017. Mr. London has had his 1,000 hours community service sentence where he was supposed to go speak to students about the dangers of drinking and driving rescinded in December of 2018. The mission of Mothers Against Drunk Driving is to end drunk driving, help fight drug driving, support the victims of these violent crimes, and prevent underage drinking. We support full-term sentences, and we support the enforcement of those sentences, as in the case of Andrew David London. I respectfully urge the court to enforce Andrew David London's original sentence and deny the request for release from probation. Releasing him sooner sends a message to the community that it is okay to drink and drive underage. Mr. London will be young enough to start his life over once his 15-year sentence is complete. Even Mr. London's full sentence is shorter than the time that Adam was alive on the earth. MAD also urges the court to consider adding an ignition interlock to his driver's license permit if Mr. London is allowed to drive the remainder of his probation. The device is designed to keep a person from operating a car if they are under the influence. Since he was allowed to change the terms of his probation by getting out of sharing his story to educate others on the preventable crime he committed, then the victim family asked that they should be allowed to change the terms of his driving if he is granted permission for a permit while still on probation. I thank you very much for your consideration on behalf of the Stevens family, all victims and survivors of DUI, and all those who reside, visit, or pass through the state of Georgia.
Thank you, Ms. Higgins. And thank you, Ms. Higgins, for sharing.
I will now go to Stephanie Goins, Stephanie, Goins, Goins. Dear Judge McBurney, my name is Stephanie Goins. I was a close friend to Adam Stevens before his passing. I'm writing to offer my objection to Mr. Andrew London's probation being prematurely ended and his record expunged. Since that terrible day in 2009, my and many other lives have been irrevocably changed by the poor decisions and unfortunate actions of Mr. Andrew London. There is not a day that passes that I do not think of Adam. I often think about how much his family and friends have missed out on, things that Andrew London still has the opportunity to accomplish and do. In the over 10 years since the crash, Andrew London has not apologized to or attempted any restorative justice with the Stevens family or others for the death of their son, brother, and friend. Furthermore, I have never seen Andrew London express any remorse for causing the death of his friend. I feel it is unfortunate that Andrew London is seeking to have his record expunged and probation ended early. The pain and suffering that Andrew London and his family face because of his sentence will end eventually, but for those of us who love Adam, we will carry this pain with us forever. I ask that the court please continue with his probation so that we may feel some sort of justice in this matter. Thank you, Stephanie Goins. And this comes from John Stevens' father. Good morning, Judge McBurney. I'm responding regarding Mr. London's request for early probation. We hope Mr. London has taken meaningful actions to right the course for himself and others affected by Adam's death. We regret that we have not heard from Mr. London, nor can we truly understand his current state of affairs. We understand that Mr. London has received a reduced sentence, and we did not pursue a civil case against Mr. London. Again, we did not hear from Mr. London as it pertains to an apology or any feelings of remorse. Our family life has changed immensely due to Mr. London's poor decisions. There is never-ending grief. We came very close to a divorce, years of depression, and holidays and Adam's birthday are heavy days with only memories. We miss and love him so much. Concerning Mr. London's probation, we understand it to be a paper probation, not requiring him to appear in front of an officer. His probation serves as a reminder, a deterrent to prevent further bad decisions. It appears at this point in time, Mr. London's probation is the only justice for Adam and our family. We hope the court will deny Mr. London an early probation, nor expunge his legal ties to our son's needless and early death. Respectfully submitted, John D. Stevens, Father.
Thank you, Mr. Stevens. Mr. Stevens, is there anything you want to add, or are you comfortable with what Ms. Rolak has read on your behalf?
First of all, thank you very much for reading that, and it's highly emotional hearing it back. And I want to congratulate Andrew on his degrees and the status of not being a felon. I think that's worth mentioning. The effects on our family have been everlasting. It's a tear you never wipe away, and we feel that we want to do what's right for our son as well as for all of those affected. And we feel this deterrent, this probation has and may prevent future issues. And that is the reason we're believing it's important. And we just wish everybody the best here out of this tragedy, and hope life goes on for Andrew in the best way possible. But we also wish that our son was here, getting those degrees and being able to live his life. And so thank you for your time.
Thank you, Mr. Stevens, for sharing that additional. Mr. Pinion?
Thank you, Your Honor. I won't be much longer. This was not my original case either. And I did not interject I'm sorry, I didn't have any interaction with Mr. Stevens early on, but I could feel his pain, as I think you could just hear still. And I do believe that what he says in the letter that about the birthdays, holidays, and how this almost tore his marriage apart is true. This was it sounds like a blind plea, and that a lot of consideration was taken in on this. And we know that the defendant did not have to serve his whole sentence. He was paroled out before the 6 years was completed. Then we know that the family of Adam wanted the defendant to speak about the dangers of drunk driving, and then that was changed. That was an earlier modification, so that was somewhat of a blow to him, that he has gotten his driver's license back, which does seem to be in contradiction to the original order. And so what we're here for then is a second modification, and he's already gotten 2 benefits. And I think it's worth mentioning that Mr. John Stevens has expressed to me he is not looking for vengeance. If he was, he would have brought a civil suit and tried to follow the defendant.
And I didn't hear that in his voice just now. It's hurt, it's sadness. It's probably sadness for Mr. London as well. It's not easy for him, but clearly there's a hole in the family that you can't refill. But I thought that he was very gracious in his comments and wasn't yelling and calling Mr. London a killer. So.
Yes, Your Honor. And I'll just end with that. This is also a first offender, which was graciously granted by Judge Glanville, and a termination of probation would then completely clear his record. I looked on the website, and it does not show any record for the defendant if you do a query of past incarceration, because he was given first offender. And that basically just puts an end to it. And I do believe we could clarify with probation. I think he's even on non-reporting probation. So
which, so we're all understanding, would be the natural course of events for someone who has completed all the conditions imposed by the judge and is now several years past that. And that's not special treatment for Mr. London. That's my understanding would be anyone on probation if he had completed the community service, paid a fine, etc. So to me, that's not remarkable. It may seem inappropriate to folks listening in, but that would not be at the request of Mr. London's lawyers or some special treatment for him.
And I agree with that, Your Honor. And I explain that to Mr. Stevens, because he wasn't informed of that at the time. So yes, that is true. But bottom line, that this would be the end of it. It would be wiped away from Mr. London's record. And that is just too heavy of a blow to the community and to the Stevens family, understandably. And that is why we oppose the modification. Thank you.
Thank you, Mr. Pinion, for stepping in on this one. Mr. Aurora, as I said, I'll give you the final word. You've been able to hear some of the concerns and the feelings of folks who are understandably upset and still processing grief and loss. Anything you want to add beyond what you and Mr. London and the many letters of support that he has have already shared?
Judge, every family obviously is going to feel terrible. The point is, Mr. London feels terrible as well, and he wished he could have reached out to them earlier, but the court understands. But for the government to come in here and say he's getting some benefit or whatnot, and it's not fair, flies in the face of the statute, which gives you behavioral incentives to get off probation early if you do everything. I challenge the court to say that anybody you've had in your years as a judge has done any more than this gentleman has. And he didn't get any benefit with regards to not speaking to schools. No school would allow him to speak. We tried to do that. That's the only reason we had it modified, is because he couldn't do it. And he ended up essentially doing double the community service hours because he couldn't do it that way. He'd done others on his own, which he'd been approved for. And then probation changed their mind. And so he ended up going to the recycling center.
Okay. Well, I do think it's important for everyone listening in to understand that even though the word rescind was used in the order that Judge Downs, or I think it was Judge Reeder, entered, Mr. London was not allowed to do less than 1,500 hours of community service. You're saying it was much more. Bottom line is, it was at least 1,500.
Yes.
The frustrating part, and it sounds like it was frustrating for Mr. London as well, particularly frustrating for the Stevens family and for MAD and their perspective, is that the very creative notion of you're going to spend your time educating people on what not to do. And the high school audience is where you ought to be. That's who we're talking about here. That was tried and it didn't work. Kind of shame on the schools for not letting Mr. London talk. I mean, who better than someone who could say, I spent the first 5 years of my adult life in prison because of stupid choices I made that you're probably making every weekend. And it's by the grace of God, you didn't run into a tree or a power pole or something. You need to knock it off, and here's proof. But I'm not allowed to do that. I get that. So I'm not processing this as somehow Mr. London got a break on probation, apart from maybe the driving thing. But we're going to explore that separately.
And with regards to the 5 years, I mean, it's just putting everything on a status quo. I mean, he's filled every incentive that he can do. If we're just going to put everything on hold just for the sake of non-reporting probation, it doesn't seem to really make any sense for the victim's family or for the state or whoever it's out there. It just seems like you want to reward somebody that's done everything. And he is remorseful. I can't imagine the court would think he's going to reoffend or do any of those things since he's passed every single drug test. So I would just ask that if you don't want to terminate it early, maybe what you'd suggested in the prior case as a suspension might be able to help him out. Because essentially it's tantamount to where he is now, which just would be a different word, and maybe legally that might help us.
Okay, thank you. So it's always helpful to hear both sides of the situation. Mr. London, you spoke from your heart. I appreciate what you shared. It is unfortunate that it has taken this many years for Mr. Stevens to be able to hear you say you're sorry. I don't know if Ms. Goins is listening in. This is being broadcast so that the public can participate. It sounds like you have wanted to say you're sorry for a while, but decisions were made such that that didn't happen. I suspect you've been saying sorry to Adam every day, certainly every day you were in custody. And you can't give back what you took. You made some choices that are irreversible and have harmed folks irreparably. I don't view you as a killer. I appreciate Ms. Hagan's perspective But I don't think there's any sense that there were intentional actions taken, other than that you drank and you drove. You made those decisions. And for that, you are paying a price that Judge Glanville, in his wisdom, determined was commensurate with the harm that you caused. Because there's no question your choices led to Mr. Stevens' death. But this is not an intentional situation. I don't view you as a killer. Your actions took a life, but you were 19 at the time. And we have well-meaning advocates who are trying to push the age for juvenile offenders to 21 because of the way the human mind still isn't wired right, and people are impulsive up through 21 or beyond. Georgia's behind the times in that juveniles at 17, and then you're an adult and you can face adult sanctions for things you've done after 17. Federally, it's 18. As I said, there's states that are pushing to make it even beyond that. So I think actually the fact that you were underage drinking is a mitigating factor. It's a crime. You're not supposed to be drinking at age 19, but you were not a responsible 35-year-old business person who went to a bar and got drunk and killed someone. I think that's even more appalling than what you did. That said, I'm not trying to diminish in any way what you did. Your actions took the life of your friend, Mr. Stevens' son, brother to sisters, and the particularly close friend of Ms. Goins. And no amount of praying or recitation of Proverbs or bettering yourself fixes that. That is a permanent harm that you have inflicted. It's a tough time of year for us to be talking about all this, because that hole that Mr. Stevens described is particularly visible as people prepare for Thanksgiving and the winter holidays. So I can understand why this is even more difficult for him and his family right now. But I believe that you would do anything and everything you could to take back those decisions. And every day it sounds like you're reminded of it through being with your brother and supporting him. I don't mean to minimize the harm that you caused there as well. It's great that your brother is functioning and is out there and is working. And I think that's some good news that comes out of this real sad situation. So I will tell you that I'm not inclined to modify your probation right now. And I want to explain why. It's not because anything you said or failed to say. It's because you struggling to get the job you really want is, I think, an appropriate consequence of the sentence that Judge Glanville handed down. He heard a lot that day you were sentenced, some of it from you and your lawyer, and some of it from the state, and no doubt victim impact statements. He could have sentenced you to more time in prison, but he felt that some prison was the right amount, followed by some probation. He's been a judge a lot longer than I have, and he was well aware that someone being on probation and having these charges is going to struggle a little bit more than someone with no record in finding a job. I work real closely with clients in drug court. These are people with 3, 4, 5, 6 felony convictions. They don't even bother checking boxes. They go in saying, you know what, I have been in prison half my life. But they find work. And when I am spending time with them, they tell me it's not the job I want forever, but it's the work I'll do now to get by while I'm in drug court. They've taken jobs. You may have helped some of them get jobs. They're getting temp agency jobs doing construction work, et cetera. And they're not making as much as they'd like, but they get by. And it's a consequence of their sentence. And so I hear you that you would like to be doing a different type of work. But I think that part of the sanction, the penalty for what happened way back when you drank and drove and it cost Adam Stevens his life, one of the consequences, which is not nearly as permanent as the memories you'll have of what happened, the loss to Mr. Stevens' family, is that for a few more years, you're not going to have the job you know you're qualified for. I know you're qualified for, that you got the academic credentials for, but that it's just it is an ongoing consequence. Mr. Aurora is right. You have checked every box and then some, is what was part of your probation. But I think that Judge Glanville, in working through this, was aware that for a few years beyond you taking care of the community, paying the fine, et cetera, life was going to be complicated because you were still under sentence. He could have given you a longer probationary term. I mean, given what you were charged with, everything could have been stretched out more. The prison time, the probation time, but he seems to have struck what seems to me a reasonable balance in his mind, the right balance, given what happened. It wasn't that you ran a red light and you killed a dog or you injured someone, but I don't need to repeat it. You live it. I didn't know Adam Stevens. And so I feel the loss in hearing from people, but that's 1 degree removed. So I commend you for everything you've done to get yourself in very much the right place so that when your sentence is complete, you, unlike Adam Stevens, will have an opportunity to pursue a career and make something out of the remaining 40 or 50 years of your life. Not so for Mr. Stevens. And it sounds like for your brother, there'll be some things he may have wanted to do that maybe he's not going to be able to do again as a result of what happened that fateful night. So I am hearing both sides. I don't think that your request through Mr. Aurora is unreasonable. I understand why it's being made. But I do think that given your agency, your role in what happened here, that it's appropriate for probation to last a little longer and for you to bear those consequences. And they're meaningful. You're not in prison, so it's a whole lot better. And you're working, you're underutilized. You could be doing other things. I get that. I don't think you're at risk of losing your job tomorrow because your employer suddenly asks you, well, tell me a little bit more about your arrest record. But what I know from my experience with these folks who are literally climbing out of a dumpster to start over through drug court is that there are a whole lot of jobs you could do that'll pay and take care of you and your family. You may not like them and they may get dirt under your nails, but they're not going to make you a worse person. And you've got light at the end of the tunnel. The folks I work with in drug court, those 8 felonies, they're not going anywhere. They might get to be a supervisor in a warehouse someday, but that's where they max out. You have a second chance. Can't say that about Adam Stevens, but you've got a second chance. Your sentence is going to end. And when it's over, I'm not involved with expungement. I heard a lot of grumbling about expungement. That's not what we're talking about today. But as a first offender, I know you're going to finish your sentence with no trouble. You're not going to get arrested again. Then from a legal perspective, this is behind you. You're not going to forget, but it's behind you. And the places you want to go, you can go. Those boxes that you've had to check on applications or things you've had to share in interviews, you don't have to share anymore. And you'll be free of that burden. But I think it's a burden that Judge Glanville crafted that is appropriate given the seriousness of what happened. I hope that for Mr. Stevens and his family, seeing and hearing you say I'm sorry is a step forward for them. It's certainly a step forward for you. And it may well be, and Mr. Aurora can talk with Ms. Rolak, that's the victim witness advocate, that it would be perfectly appropriate for you to write something down and that could get sent to the Stevenses. They may not want to hear anything more, but that may be meaningful for them, and it may be somewhat of a important process for you to put words to paper. I'm not requiring that. I'm just saying there's now a channel that's been developed. The one thing that we're going to leave open is that I'm going to ask Mr. Pinion to get someone on his staff to see if they can get the transcript of your sentencing. I don't want you to be unnecessarily running afoul of Judge Glanville's sentence. And there's that murky language on there about driver's license revoked. If you're not supposed to have a driver's license right now because of his sentence, we need to fix that. You haven't done anything wrong. You did everything you were supposed to. And the Department of Motor Vehicles has said, here's your license and you're driving. And maybe what we do, and someone mentioned this today, is we get an interlock device in there. Who knows? I'm not trying to set you back, but I do need to make sure that you aren't unintentionally violating a condition that Judge Glanville put on your sentence. And that was before Mr. Aurora. He wasn't involved then. So, Mr. Pinion, if you could get someone, it's not an odyssey. Someone's going to need to get the transcript. Clerk's office will get it to you. And just let me know if the language isn't clear. We won't change anything. But if the language is clear, then we may need to have a discussion about it. And it may be that's a condition of probation I'm willing to modify so that you can work. Because I wouldn't want you to be unable to work. But if you are going to be driving, we may just want to have certain conditions about how that driving goes. You don't need to change anything you're doing right now. We'll wait. We'll get that transcript. Mr. Pinion will share it with Mr. Aurora. We'll have a conversation about it. And if anything's going to change, it'll only be after Mr. Aurora gets a chance to speak on your behalf and Mr. Pinion or one of his colleagues share something from the state. So that's how we're going to handle this one. Mr. Stevens, I wish you and your family the best during this holiday season. I hope that you continue to process this in what sounded to me to be as healthy a way as you can. I did not hear animus in your voice towards Mr. London. I hope no one is casting this as some intentional act on his part, but it certainly had repercussions that resonate today and will continue for years to come. And then Mr. London, I hope that you feel like I heard you. I did. And I just shared with you as best I could why I think it's appropriate that you labor under the impact of probation. To Mr. Aurora's point, there aren't other conditions other than maybe this driving one that you still need to comply with, but they're consequences of the probation. And I think they're consequences that were intended based on the manner in which the sentence was imposed. And folks who are listening, I'm going to reiterate the fact that Mr. London is not reporting to a probation officer or there aren't other things that he still needs to do is entirely consistent with someone who has done well on probation at this point. That's how it would work for anyone and everyone, and he ought not to be treated differently if he's doing well on probation. So this non-reporting status is, to me, not remarkable. Mr. Aurora, anything you want to add at this point?
No, Your Honor.
Okay. Mr. Pinion?
No, Your Honor.
You'll let us know about the transcript?
Yes, Your Honor.
Okay. All right. Thank you, everyone.
Thank
you. In
Okay.
about a minute, we will pivot to Mr. Slayton's matter. I know Mr. King and Ms. Convery have been on for a while. I'm just going to give Mr. Forte a break and let folks get out of here, and then we'll talk about Mr. Slayton. Thank you all. So I guess there are due outs from both sides, but different cases. You'll find out from Pennsylvania if suspended works, and you'll find out, Mr. Pinion, about that transcript. And Mr. London, I just want to thank you for the efforts you've taken. You have landed on your feet after something that could have driven someone to addiction or who knows where. So I appreciate what you've done, and you will fly free of, at least, as I said, the legal side of this. There's going to be a burden you're carrying forever. You know that, but sooner than you think, this legal part will be behind you, and you'll be an IT exec or whatever it is you're going to do, and you'll be there for your family. All right. Thank you, Mr. Aurora, Mr. Rafis. And Mr. Pinion, you're free to go. Ms. Convery's on the call. She's handling this bond reconsideration. All right, Mr. Forte is taking a quick break. When he has refreshed, we will start up again.
It's nice to see somebody doing well on their probation and doing all the stuff they're supposed to do.
Wouldn't you like to have more clients like that?
I sure would. I sure would.
Mr. King, how old is Mr. Slayton?
17.
Okay, so I don't think we need probation then, because he's not going to have an adult criminal history. Is that a fair statement?
That's a fair statement.
Okay.
Thank you, Judge. Have a good weekend. I'll see you on December 2nd. I think we have.
That's a long time from now. You promise you'll come back?
Maybe. Yes, I'll be back. Thank you.
All right, take care. So I wouldn't prioritize either of those. That one's done. One we just did is done. The other one, I know what we talked about. They just get information from them. Yeah, I would do that. It's just okay. Let's get started. This is 20 SC 175651, State versus Mr. Slayton. He is one of, I believe, 3 defendants in this case. And we are here to talk about bond for Mr. Slayton. I have considered bond in the past. That may have been before Mr. King was involved. I know Mr. King had asked that we look into the question of bond again. In June of this year, June 5, I entered an order denying bond for Mr. Slayton. I've heard a fair amount about the facts and circumstances of the case, and it may have been in Mr. Slayton's bond hearing, it may have been in one of the co-defendants, but we'll probably need to talk about it a little bit more, because I am not remembering who is associated with what action, but this was a fairly high profile and pretty violent armed robbery, smashing things, taking things, etc. So we're talking about a serious case. This is not someone caught in a stolen car. So it's a complicated concept to begin with, just given the nature of the charges. But Mr. King, I'm going to let you start and let me know why you think I ought to undo the decision I made a while back.
Thanks, Judge. I want to start by explaining what my client's role is in the situation, and just being candid about everything that's going on. Number one, he was the individual who walked into this establishment with a bag that had a hammer in it, while there was at least one gun brandished by a co-defendant and pointed at one of the victims. That I don't know if there was 2, but I know there was at least 1 allegedly. And my client never had a gun, but he did smash some glass, and I believe he was accused of taking some watches. As he ran out, he got tackled, and after he was tackled, he was held down by, I believe, 2 victims/witnesses. And in a candid nature, he made some statements, according to the victims, that he was going to come back and beat one of them up, beat their ass or something like that. And then one of them claimed that my client said that he was a member of the Bloods. So I just wanted to get that out there, let you know this is what's alleged, apparently afterwards, the others got into a vehicle, into a chase, and a crash ensued. One person got away. So there's one person that is the state does not have an identification for. That's what my client's role was in this situation. I do want to talk a little bit about his history. I do have his juvenile history that was provided by the state in discovery, and he has a marijuana and possession of a controlled substance from charged in 2019, and that's it. And one of the things that was pending during the last hearing was a charge that I believe began as a felony in DeKalb County. It was a domestic. He was transferred to DeKalb County for resolution of that case. And a little bit about that case is his mother and his sister were in a fight, and he jumped into the ruckus and broke it up. And somehow he ended up being charged along with his mother. And during the resolution, he ended up getting a misdemeanor 6 months probation while he was still incarcerated for this charge. So, in my opinion, it's really not over his head anymore. So that's the extent of his history and what's going on with him as far as the justice system. He was, prior to this incident, he was a really good student. My understanding, he was a 4.0 student, and he was in school doing well. I don't not have any idea about any other violent history. He has strong family support and family ties. His mother and his father are either on here or on the YouTube. They've been at his side throughout the whole thing. I have spoken to them more times than I can count, and they're in strong support of everything that's going on here. When it comes to Ayala factors, I think that his strong family support, him basically being raised by his mom and his dad, would lean toward that factor being in his favor as far as him not being a flight risk. Basically, there's nowhere to go. He's a young guy who knows nothing else but his family in this situation. He has no violent history, so I don't think that we can look at this situation as there's some sort of past that we can show that would predict the future, except for this horrible situation he found himself in on that day. His potential for intimidating witnesses is concerning because of the statements that one of the victims stated he said. I haven't been able to find any evidence that supports what he said, and but we acknowledge that their allegation is that he claimed that he was in a gang and he was going to come back and beat the person up. We don't want to shy away from what these allegations are. And with that being said, Judge, I just would ask that in the consideration here, that the thought or the concern be alleviated with an ankle monitor and a 24-hour curfew. And obviously, any possible way that through social media or phone that he can communicate be limited. And then I just don't think there's anything specific about his actions here or his previous actions that would support a major concern for the threat to the community. This is a violent crime. This is a serious incident. I believe my client is very remorseful for his role in the situation, and I've talked to him multiple times. But I do want to, in a way, distinguish him from the others in this situation. Number one, they made matters worse by putting other lives at risk in the car. And I understand my client was stopped, but he did not participate in the chase. My understanding is that there's some violent histories with the co-defendants, but obviously I don't know exactly what they are. And then also his role, he never pointed a gun. He never had a gun. And so I just think that if we rank the seriousness of the activity, my client is at the bottom here, not wanting to state that he should not take responsibility or there's no responsibility to be taken. But I do believe that there is some distinguishing factors here. My understanding, Judge, and I was not part of the hearing, my understanding is that you were considering it, and I can't put any words in your mouth, of course, but you were very concerned about him having an open situation in the cab and wanted to know how that would be resolved. And that has been resolved, and he has a 6-month probation, and I believe it was a simple assault that it was resolved as. And because of that, Judge, because of his family support, we would just ask that you consider giving him a bond. And I want to see him get further his education. So what I would ask that it be a condition that anytime he has the opportunity that he enroll in whatever he can enroll in to further his education, because it sounds like he was on a good track and he ended up, making a big mistake in this situation, a bad decision. So with that, Judge, I would just ask that you give him a reasonable bond in this situation. I would ask for a $20,000 bond.
Okay. Mr. King, where would Mr. Slayton stay?
Mr. Slayton would stay with his father, and Mr. Calhoun, who is on the call, that address, getting it for you right now, Judge.
I don't need the address right away. We will need it if
Right.
play out.
If he were to be released, he would live with his father, and he has an apartment in East Point.
Okay. Do you know where Mr. Slayton was staying back when this happened?
Yes, he was staying with his father.
Okay. I will let you have the last word after I hear from Ms. Convery, and then there may be something that Ms. Rolak has to share from any one of the many victims in this case. Good afternoon, Ms. Convery.
Good afternoon, Judge, and I hope my internet cooperates. I'm actually in a hotel or in a hospital sort of lobby in Ohio, so if the court can't hear me, just let me know. I'm going to be somewhat brief. I know the court has heard this case from a variety of perspectives at this point, and I don't disagree with much of what Mr. King outlined to the court as far as a factual basis. This defendant is alleged to be the defendant that has the hammer and go inside. Essentially, the three guys sort of line up outside. There is an older defendant, and then Mr. Slayton and Mr. Robinson are significantly younger than Mr. Collier. When they make entry into the location, that's sort of everybody knows what time it is, I think is essentially what the first statement is. Mr. Slayton pulls out a hammer of the bag that he has with him, starts smashing the jewelry cases and loading up the items that he can quickly grab into that duffel bag. Meanwhile, the other two defendants, Mr. Collier and Mr. Robinson, have either a firearm or a replica of a firearm. I think one actually ends up being sort of a plastic BB gun type situation that appears like a real firearm, and Mr. Collier has a 380, I believe, in his hand. It just so happens that sort of on their way out, one of the victims in this case, the actual owner of the jewelry store, is returning back from a lunch break. He's able to, and I've told him this probably wasn't the smartest decision, but he's able to sort of apprehend and detain this defendant on the way out. And in the struggle, the owner of the store and Mr. Robert Gale, which I think the court's going to hear a quick statement from, he is actually injured during the altercation, but they're able to sort of pin him down and hold him until Sandy Springs arrive, which is a short time later. as Mr. King predicted, that is of serious concern to the state, what happens there in that next window, because candidly with the court, because the victims are pretty terrified about that. They've certainly never been in a situation like this before. And to have someone, while you're holding them down, they know they're caught at that point and they're still telling you that they're going to be back and they're not going to come back alone. They're going to come back with their fellow blood members and hold them responsible for basically detaining him on the scene. So those people are terrified about that. And they feel pretty strongly about this defendant remaining in a no bond status. As far as I'm concerned with bond factors, I think my primary concern is him being a risk to reoffend if he's given a bond. He did have the DeKalb situation pending when this happened. And my focus isn't necessarily the severity of that situation, but the fact that you've got an open pending felony situation. And I hope Mr. King corrects me, but I believe, and I told the court last time, I believe that did start as an aggravated assault. I don't have that document in front of me though, so I could be wrong. But again, my concern isn't about the severity, just that that's pending and open and you participate in a planned armed robbery. This wasn't someone they saw on the street. This was a plan to go into a jewelry location and do the most damage they could in a short period of time, armed. Certainly he wasn't involved in the chase afterwards, but I think that's because he didn't have the opportunity to, from my perspective. From my victim's vantage point, he's certainly a risk to intimidate them, and they're certainly concerned about that. But just candidly, my primary issue and the reason I'm asking that the court hold him in a no bond status is that risk to reoffend concern. Certainly if the court was inclined to grant a bond in this situation, I think an ankle monitor makes sense, but I just, I've been burned on that a few times recently. I don't know that that's an appropriate situation here. This case also is evidence-wise. I know the court's not looking at the specific facts when you're thinking about bond, but as far as the strength of the case is concerned, it's pretty strong in the way of evidence, and he's got some significant decisions ahead of him as far as where we go with this case. I've been speaking with Mr. King about possibly having a conversation, but I don't know from any information provided that will make this something that means we're going home at the end of the day. So I'm gonna keep it to that. I know Ms. Rolek has a brief statement from Mr. Robert Gale that she'd like to read. This was an individual that was inside the store when the robbery sort of unfolded, and he's one of the guys that was there when they're holding the defendant before police arrive.
Great. I'll hear from Ms. Rolek in just a second. Mr. King, do you agree that the DeKalb situation, which has since been resolved as a misdemeanor, whatever it was originally charged as, but it has since been resolved, but that DeKalb matter was open and pending before this incident occurred?
Yes.
Okay, thank you. I just wanted to understand the timeline. Ms. Rolek.
Good morning. Well, good afternoon again, Judge. With regards to the owners of the jewelry store, the victim Arkady Yakubova and his wife Esfira Abramova, I wasn't able to get a written victim impact statement from them due to the short notice that we had for this hearing. However, I was able to get one from Robert Gale, who is a witness. But they, as Ms. Convery said, they're very much opposed to bond. Robert Gale says, "Good afternoon, Judge McBurney. It's almost a year and I'm still working on getting myself in a safe place. Each and every day, I pass the location where my life was threatened. It's a common reality where I have explained to my young daughter on the way to Publix for weekly shopping across the street from my residence. I don't know how long these feelings will resonate in my mind. For the safety of all of Atlanta, please deny bond to Antonia Slayton. He doesn't deserve to see the light of day. Thank you. Respectfully submitted, Robert Gale."
Thank you, Ms. Rolak, for sharing that on behalf of Mr. Gale.
And they are watching on the YouTube live feed.
Okay, well, hopefully they are able to see and hear what it is we're doing. Mr. King, anything you want to say in summation from Mr. Slayton's side, having heard what Ms. Convery had to share?
Yes, Judge, just very briefly, Judge. My client was a juvenile at this time. I'm sure if he was speaking to you right now, he would tell you he would take back his actions, but he can't. But at the same time, I do believe that when it comes to the factors here, he should be entitled to a bond. And I just think that the fact that he was a little younger than everyone else puts him in a slightly different situation because of his lack of maturity. And obviously that can go both ways, but I would ask that that be taken into consideration, and his lack of previous history also be taken into consideration, Judge. That's all I have. Everybody knows exactly what everyone's positions here, so there's nothing else that I can provide. But I definitely want to just remind everyone here that at the time of this incident, he was a juvenile, and he's suffered a lot of consequences so far. Never having even spent much time in jail, maybe one night due to a previous case, but now he's been in jail since January. So it's not as if he hasn't suffered, and possibly will end up having to suffer more. And that's all I have to say, Judge.
Okay. Well, thank you, Mr. King. It's been
Thank
helpful
you.
to get the refresher from you, and also to get that update about the DeKalb situation.
Yes, sir.
I agree with you that Mr. Slayton finds himself in a pretty complicated situation. My concern is that giving him a bond, regardless of the conditions, I don't believe that would make his situation simpler. I think that it would create some risks for Mr. Slayton. Certainly risks for Mr. Gale and Alex, et cetera. I don't mean to ignore or minimize their concerns. I hear those loud and clear, and I think the factor of intimidating witnesses weighs heavily against Mr. Slayton. But thinking about Mr. Slayton and what awaits him in light of what it sounds like the evidence is going to be in this case, I don't think we make his situation simpler by getting him back into a living situation, which of course was the living situation he was in when this incident happened at the jewelry store. So I continue to find that there is not a set of conditions, even if it were an ankle monitor, which, like Ms. Convery, I'm finding to be less and less of an assistant in ensuring that people stay put and stay out of trouble. We may need to come up with another way to affix them.
Judge, just one thing. I did want to just say this. It probably won't change your mind, but there are other places he could stay if the location was a major concern for you.
Okay, no, I appreciate that. And I would have pressed you if that's what I was hung up on. I would have asked, well, are there other places? I appreciate that Mr. Slayton has a support network. That's good, and he needs it. He's got a great lawyer. But that support network that, of course, was in place at the time this incident happened is something we will work through in the future. It's not something that gives me the comfort level that there is a set of conditions that I could impose that would ensure Mr. Slayton's appearance, and even more so, Mr. Slayton staying out of trouble. I hear you loud and clear, Mr. King, that he was the youngest of the bunch, and I think that is a mitigating factor, and it may well help you get some traction as you negotiate with the state on what would be a fair resolution for Mr. Slayton. The same can't be said for the co-defendants, but he went in with eyes wide open, and the things happened that are alleged to have happened. We'll work through those consequences. But for now, I'm going to keep Mr. Slayton where he is. The good news is, this is minor good news, but it's not bad news. We hope in January to restart with trials. So Mr. Slayton doesn't face the uncertainty of, well, when might there be resolution of my case? He may resolve his case before trial, but certainly having a case set down for trial is a very good forcing mechanism to get the lawyers to meet and speak about reasonable outcomes in the case. If for some reason, Mr. King, this case gets stuck somewhere and is not advancing, let's talk about this again. I'm mindful of what you're saying, that for someone Mr. Slayton's age, being locked up for this long is not helping him develop. He's not finishing his education or anything like that. And so we can revisit this if the case stalls out. I suspect Ms. Convery and her colleagues will keep it moving and really will just be in the queue to have a trial. All right, that's what we're going to do for now. I appreciate folks being involved and arranging this hearing. Everyone have a safe holiday. Ms. Convery, I hope everything is okay. You being in a hospital in another state suggests it might not be for someone close to you, but I hope things are all right. And I will see
Better today.
Better today. Good. I will see folks soon. All
Thank
right.
you, Judge. Have a good holiday week.
All right. Take care. Bye-bye.
Thanks, Judge.